Are you a DC tenant with a case in Landlord-Tenant Court? My name is Jordan, and I am an attorney on the housing team at Neighborhood Legal Services program, where I help my clients whose landlords have sued to evict them. In today's video, I'm going to give you some information about what to do if you missed your hearing. This information is meant to help tenants who are representing themselves in court without a lawyer, which is called being a pro se tenant. If you would like to see if you qualify for free legal assistance, you can call the Landlord-Tenant Legal Assistance Network, or LTLAN, at 202-780-2575. The information in this video is not legal advice, and it is specific to courts in Washington, D.C., because the laws vary across the country. Today we'll review three main topics. 1. How to know if you missed your hearing. 2. The possible outcomes of missing your hearing. And 3. What you should do if you miss your hearing. First, let's go over how you know if you missed your hearing. You can find out information about your case, including the date and time of your hearing, by checking the court docket. You can find your court docket at this link. The link lists all of the events and documents in your case, and it is sometimes called Odyssey. So once you've checked the link in the caption, your screen should look something like this. In the search bar, to find your case, you can either type your last name, comma first name, or your case number. The case number must be entered without spaces or with hyphens. If you use spaces, your case will not come up. Then complete the I am not a robot task and click submit. Now you should see your case's docket. If you don't see your case or you'd like assistance checking your docket, you can also call the clerk's office. The number is in the caption below. We will begin by showing an example docket on the screen. And when you look at your own court docket, you'll see information in place of the black boxes in this form we're showing. So once you see your docket, you'll see a PDF titled Initial Hearing Notice and Instructions for LT. The initial hearing is the court's term for the first hearing in a case. When you click on the PDF, it will save to your downloads folder on your phone or laptop. When you open it, it will look similar to this form. Again, you'll see your information in place of the black boxes on this form we're showing here. The PDF will include instructions about how to attend your hearing in person or online, as well as the date, time, and location of your first hearing. For example, here on this docket, the date is May 5th, 2025, for the remote initial hearing. Now, if the date of your hearing is in the future, it is extremely important that you attend it. If you have a serious conflict, such as a medical emergency with that particular date, you can call the clerk's office at the phone number in the caption below and request a new date by asking for what's called an emergency continuance. These are not guaranteed to be approved, but it is still important to ask. If the date of your hearing has already passed, that means that you missed it. That brings us to the second topic of this video: possible outcomes of missing your hearing and what steps you should take to give yourself the best shot in court. So let's go over 4 possible outcomes together. Firstly, your case could have been continued, which means postponed, for another hearing. A continuance means that the judge rescheduled your hearing date and set another hearing. This would usually only happen if your landlord had requested that the hearing be postponed. If you see a default judgment, or a writ on your docket, stay tuned for those explanations. If your case was continued, your docket will have a new date set for a different hearing. For example, the most common continuances postpone an initial hearing by scheduling a further initial hearing. If this happens in your case, your docket will look like this. So what should you do? When your case is continued, it is very important that you attend your next hearing. If you absolutely cannot attend for reasons like a medical emergency, you can call the clerk's office and request that it be rescheduled, called an emergency continuance. The second possible outcome of missing your hearing is that the judge enters a default in your case. If that happens, your docket will look like this or this. A default or default judgment is something that the judge can enter against you when you don't attend your hearing. This is bad for your case because a default judgment goes on your court record and is visible to other future landlords for up to 3 years. It can also allow your landlord to move forward with an eviction if you don't take steps to undo it. It's important to note that though a default can be harmful to your case, it can also be undone, or in the court's term, vacated. So, what you should do to undo a default. Well, firstly, if there's a default entered against you, you absolutely need to file a form called a motion to vacate the default. You should also file another form called an answer, which we'll explain soon. So let's start by going over the motion to vacate the default. The form looks like this. The form explains why you missed the hearing and why the default judgment should be undone. As you can see, the form has a small space for you to write an explanation of why you couldn't attend your hearing. If you need more space, you can always write on a second page and attach it with your motion. If you missed your hearing because you didn't know about it, or because there was an emergency, you should definitely include that on the form. There are many factors that a judge will consider when deciding whether to vacate your default. One important factor is how quickly you filed the form after you found out about the judgment. So you should try and file it as quickly as possible. Now, once you file the motion to vacate the default, the court will schedule another hearing for you to explain why you couldn't attend your hearing you missed and why you believe the default judgment should be undone. Make sure to check the docket online to see when the hearing is scheduled for. It should look something like this. And you should receive a paper in the mail with the date and time of the hearing. Another important factor the judge will consider is whether you have strong legal defenses. Your legal defenses will be explained in another form called an answer. That form looks like this, and it's linked in our caption below. It's a checkbox form that lists possible legal defenses, and you'll select the options that apply to you. Page 1 of the form instructs you on how to fill it out. This form is helpful because it might alert you to defenses you didn't even realize you had. Like maybe you knew your landlord hadn't fixed a housing code violation, but you didn't realize that they failed to properly provide you with notice of your court case. Now, if you have questions about legal defenses, we have a separate video on that that's also linked in our caption. Filing an answer is not required by the court, but it will give you the best opportunity to defend yourself in court. So it is very important. If you are confident in your ability to fill out these two forms, which are linked in the caption below, you can file the forms by printing them and dropping them off at the clerk's office, whose address is in the caption below. If you would like more assistance for the forms, you can call LTLAN to see if you qualify for free legal assistance. A third possible outcome is that the judge entered a default and scheduled what's called an ex parte proof hearing. If you attended any hearing in your case before you missed a hearing, the judge should schedule an ex parte proof hearing, which looks like this on your docket. This might give you an extra chance to explain why you couldn't attend the hearing and undo the default judgment against you. The only difference between this scenario and the one I just explained is that in this case, a hearing will already be scheduled. So what should you do? Again, you'll need to file those two forms, the motion to vacate the default and an answer. You'll also need to attend your next hearing. Because the ex parte proof hearing will already be scheduled, it's important to file the forms with the court before that hearing date, so the judge knows about them, and you can raise your defenses at the hearing. Filing the forms gives you the best shot in court, but if for some reason you don't file the forms, you should still attend your hearing and explain why you missed the last one and any legal defenses you have. The last outcome we'll go over is that the judge entered a default and a writ was approved. If a writ was approved in your case, your docket will look like this. A writ, also called a writ of restitution, is an order from the court to evict you from your home. What you should do if you receive a writ is immediately file an application to stay the execution of the writ of restitution, which asks the judge to cancel the eviction. The form is also linked in the caption below, and it looks like this. Your information will be in place of the boxes on the screen. In the application to stay the writ, you should tell the court if you have filed or are filing a motion to vacate a default. Tell the court if you have a pending ERAP application. Repeat the legal defenses in your case, which you can also state in your answer. Note that none of these require the judge to stay the writ, but they can be good arguments on your side, and they are important to include. If you haven't already, you should also immediately file a motion to vacate the default and an answer, as described previously. Now, once you file the application to stay the writ, the court will schedule another hearing for you to explain why you couldn't attend the hearing you missed and why you believe the default judgment should be undone. Make sure to check the docket online to see when the hearing is scheduled for. And you should also receive a piece of paper in the mail with the date and time of this hearing. In the worst case scenario, if you are not successful in undoing the default or stopping the eviction, see our flyer linked in the caption below about your rights before and after you're evicted and where you can go for assistance. The flyer is called Tenant's Guide to Post-Eviction Rights. If you'd like this information in a written format, please pause the video here and take a screenshot of the front and back of this flyer. You can check out this flyer as well as all of our other flyers on our website. Good luck, and if you have questions or want to see if you're eligible for free legal assistance, please call LTLAN.